you, Mr. Chairman, and I appreciate the answer. I didn't expect a lengthy answer. I think it's a pretty straightforward question. I also did not say ninth month. I said third trimester. Let me try a more direct question. If the legislature were to pass a restriction on any abortions, including the exception for life of the mother that were in the last trimester of a pregnancy, and there is no compelling state interest to override that, would that be in violation of this constitutional provision? I think the answer is yes, and I think it's obviously yes. And I'm just wondering why the gentle lady is reluctant to give me just the yes answer to my question. You can couch it in whatever terms, but I don't see that there could be a compelling state interest. Let's assume there is not. Based on the words that I've heard as an answer, it sounds to me like restricting abortion in legislative action would be a infringement on the right to personal reproductive autonomy. If I'm wrong, please tell me. But that's the crux of this thing. That's what the public needs to know leaving this committee meeting today. People on the street are going to want to know what we're trying to do here. And they deserve to know. I mean, it's just a matter of it's simple as that. And to have a vague answer to that question about whether third trimester abortions will be allowed effectively if they are not restricted by the legislature, and this constitutional amendment passes, would that legislation be? I got sidetracked. Never mind. The point of the matter is I need to know whether or not this would restrict any restrictions on abortion whatsoever. And just while we're at it, how about other things, even simpler things like if I put a bill in like I do every year to require parental notification for abortion, and I do so because I believe that parental notification catches bad actors. And I include in that legislation a caveat to protect young teen pregnant women who might have reason to prevent notifying their parents by using the probate court system as a mechanism to not have the parental notification go forward. But I believe that's a good policy. I believe that catches abusers and rapists and things like that. And I can understand where we might disagree on it. But I think that is a law in the majority of states in the country. And I have always hoped that we would get over that hurdle in Connecticut. We would make that the law in Connecticut. Would such a law be in violation of this constitutional provision? Through you, Mr. Chairman.
Senator Fletcher.
Through you, Mr. Chair. A law like that would have to be balanced between whether or not, if this constitutional amendment were to become a part of our Constitution, whether or not an individual's personal reproductive autonomy and freedom was violated by the law, and whether or not that was overbalanced by a restricted, compelling state interest that would require the law to be necessary.
Senator Sampson.
Thank you, Mr. Chairman, and I appreciate the answer. Again, though, I find it to be a non-answer. At some point, this is going to be debated in the public. It's going to be debated in the media, and there's going to be a lot of activity, and we're going to be getting emails back and forth about how you should vote for this and you should not vote for this. And I believe it's a disservice to the public to not have solid answers to these questions. There is intent for this legislation, and I believe that intent is clear to me, that it is to prohibit any restrictions on abortion rights whatsoever. And I'm not saying that's even right or wrong. I'm just suggesting that that's what the policy appears to do. And I think that is important for the public to know. I guess I'm done asking questions, but I will just make a couple of comments. First off, I think that the constitutional amendment, if you're going to write such a thing, you should be clear about what it is. It should contain the word abortion, as well as personal reproductive autonomy, assuming you want to include things like access to birth control, et cetera. But the primary focus of this debate is whether abortion rights should extend to the full term pregnancy or not. I believe, because to me, that is the overriding issue that is in the public. As I mentioned before, I think people fall along a spectrum, and even people that identify as pro-choice have issues with late-term abortions. And I think even people that identify as pro-life sometimes are not against every conceivable measure of birth control. And I fall in that category of somewhere in between, like a lot of people do. And that's why it's so important to know what this bill means. And I almost believe that using the term personal reproductive autonomy is deceptive. And I think that's unfortunate. And I don't think we should ever use any deceptive language in a constitutional amendment. I don't mean to be offensive by saying that, but to me, I find it that way because we don't have answers to the basic question. I think that if I'm correct, that this constitutional amendment would prohibit a parental notification law in the state of Connecticut, if it would prohibit any restriction on abortion whatsoever, including third trimester abortions where the life of the mother is not threatened, I think that's an extreme position. And I believe that the average person in the state of Connecticut will consider that an extreme position also. I also believe that's the reason for the reluctance to give a clear answer on the question, because once that becomes clear to members of the public, I think that there might be a very different, overriding public opinion on the subject. Nowhere in this constitutional amendment is the life of the unborn child considered, by the way, or is it? It says the no law shall be enacted to deny or infringe the right of personal reproductive autonomy and freedom. And if you're applying that just to the mother, certainly it means one thing. But if you consider the unborn child to also be a person who shares the same natural rights protected in our Constitution, it means something else entirely. Which is why I have said several times now that I believe that the language of the amendment should be more specific about what is being considered. At some point, every fetus becomes a life, and people differ on when that time begins. Some people believe it happens at conception. I think other people who are on this extreme pro-abortion end of the spectrum would say that doesn't occur until the baby's actually born. But I think the vast majority of members of the public would have a tough time saying that a fetus that's 8 months into a pregnancy is not a life or a child, or doesn't deserve the same constitutional protections of life that currently exist in our U.S. Constitution. And I believe that this language before us may imply that fetus is due the same protection, which is why it's unclear and why these questions are necessary and why we should have straight answers. I'm going to oppose this, Mr. Chairman. I would have liked to know more specifically whether or not the answers to my questions. But hopefully that will come out at some point, and we will know what we're debating going forward. Thank you.